Hi, I'm James Minick. With Minick Law, we concentrate in personal injury, criminal defense, and family law cases. Today, I'm going to talk about how to attack the horizontal gaze nystagmus test, how to attack that as expert testimony. And this video is really going to be designed for attorneys that are trying to keep that testimony out of evidence in a driving while impaired trial. The horizontal gaze nystagmus test is one of 3 standardized field sobriety tests that is performed by an officer on an individual that is suspected of impaired driving. It's an impairment test. In North Carolina, after the enactment of Rule 702 in terms of expert testimony, in order to be qualified as an expert, the state must show that the testimony is based on sufficient facts and data, that the testimony is the product of reliable principles and methods, and finally, that the witness has applied those principles and methods reliably to the facts of this particular case. In terms of kind of how the horizontal gaze test could be suppressed or kept out of evidence, it's basically in attacking it at the expert testimony level. And horizontal gaze nystagmus, or a witness testifying about horizontal gaze nystagmus, there are particular qualifications for testimony on that front, further laid out in Rule 702 beyond just those kind of 3 preliminary findings of an expert witness. In order to testify about horizontal gaze nystagmus, a witness, after being qualified as an expert, can talk about how horizontal gaze nystagmus shows somebody's impairment level. So they can talk about how it shows somebody is impaired. What the expert cannot talk about is how that would then translate, how the results that they see in the eyes in the horizontal gaze nystagmus test actually translate into a particular alcohol concentration. So the expert cannot talk about how the clues that they are seeing in the eyes would indicate a particular alcohol level. This is really important in attacking the horizontal gaze nystagmus test because the National Highway Safety Traffic Administration, who basically kind of set out the principles for performing standardized field sobriety tests, really seems to hone in on the fact that the horizontal gaze nystagmus, the results of the horizontal gaze nystagmus, actually show that a person has a particular alcohol concentration, that there is a probability that somebody that exhibits 4 out of 6 clues on the HGN test would then have a particular alcohol concentration. That is specifically what you're not allowed to testify about under North Carolina Rule 702. Because that is the whole purpose of the horizontal gaze nystagmus testing by NHTSA, the 2 are really in conflict. So bring that out in front of the judge, that effectively what the state is seeking to introduce is a probability of a particular alcohol concentration, not the likelihood or probability or chance that somebody is impaired. That's really not what the NHTSA findings are about. In terms of attacking the actual expert testimony related to the horizontal gaze nystagmus test, the horizontal gaze nystagmus test is a inches and seconds test. There are specific instructions that need to be given by the officer in terms of how they're telling the suspect to stand, how they're instructing the suspect to follow their stimulus, finger or pen or whatever they're using. And then during the actual administration of the test, the medical checkoff that is performed before beginning to look for clues, and then at every stage of the test, looking for lack of smooth pursuit, looking for distinct and sustained nystagmus at maximum deviation, and looking for onset of nystagmus prior to 45 degrees. At each of those stages, it's important to really question the officer about how they're performing the test, because if they're not applying the test correctly, if they're not performing the test correctly, then under Rule 702, they cannot testify about how they are an expert. Further, there is a pre-Rule 702 case before kind of adopting the Daubert expert testimony principles that talks about State versus Helms, a North Carolina case from 1998, that talks about really somebody testifying to horizontal gaze nystagmus does need to be qualified as an expert, and looks at all the other causes of nystagmus. So nystagmus is basically a involuntary jerking of the eyes. State versus Helms talks about basically 30 plus other specific causes of nystagmus, and that those are appropriate to use in cross-examination. The court said asking about the officer's training in these other causes of nystagmus is appropriate. One of the causes that is referenced by the State versus Helms case is basically having too much caffeine in your system. So again, there is a number of very innocent causes of nystagmus, and an officer that cannot say, well, here's what alcohol nystagmus looks like versus here's what caffeine-induced nystagmus or other types of nystagmus looks like, really can't reliably apply these principles and methods to an individual. If the state is arguing that they really don't need to qualify their officer as an expert, because that's not what they're trying to do. They're just trying to have this person talk about horizontal gaze as a lay person. That really is inconsistent with the specific language in Rule 702. And if the officer is basically trying to look at the horizontal gaze nystagmus test, say how many clues he's identifying, how many clues were found, and translate that into a likelihood that this person is impaired, that's what they're required to do under Rule 702. If they can't do that, then there is absolutely no value to the horizontal gaze nystagmus test. So if the district attorney gets up and says, well, Your Honor, we're not trying to qualify this officer as an expert in the administration of horizontal gaze nystagmus, he's just going to talk about generally what he saw during this test, there's no value. It's totally irrelevant evidence. If the officer is not qualified as an expert, it's valueless testimony. So if the district attorney is trying to qualify the person as just is not trying to qualify the person as an expert, but just as a lay witness, just say, Your Honor, this is irrelevant testimony unless it's being offered as expert testimony. The horizontal gaze nystagmus test is a highly technical test, and if you're attacking that test, just make sure that the state is qualifying its officer as an expert before allowing that testimony to come into evidence. Attack it immediately as soon as the state is trying to get that into evidence. Say, Your Honor, we're objecting to this evidence because the expert has not been qualified as such. This is expert testimony. The officer has not been qualified as an expert, and from that point, the state's got an uphill battle.